All rise. The Court of Appeals Division 1 is now in session.
Please be seated. We are on the record in our cause number CV210061, Kumbera versus Manickam. And I probably butchered both of those, so please correct me when you begin your presentation. These proceedings are being video and audio recorded as well as live streamed. I ask you introduce yourself and your client at the beginning of your presentation. Each side will have 20 minutes in which to present their argument. Counsel is responsible for reserving any portion of that time for rebuttal should you choose. We have read the briefs. We have discussed this case in conference. We're familiar with the facts. I'm going to ask the gentleman in the back of the courtroom, please remove your hat while in the courtroom. At this point, counsel, if you are ready.
Thank you.
Good morning, judges. Thank you for the opportunity to be here today. May it please the court, my name is Regina Pangerl, and I represent the mother in this matter, the appellant, Ms. Sundry Manickam. I would like to reserve some additional time at the end. I will try to watch the clock here. About 7 minutes would be wonderful. I understand that we have many issues. I'm not sure which issues the court is most interested in hearing more about. I would like to point out that with respect to the Amway business, the judge in the trial court did ultimately award that business to father and did divide all post-service debts from the date of service to date of ruling to be equally divided between the parties. However, what the court failed to do is to divide the profits that had been earned during that time, which had all been received by father. We believe that is legal error and that those profits need to be equally divided between the parties.
Is that different than what would have been resolved under the Rule 69 proposed agreement?
I believe that was a separate issue aside from the Rule 69 agreement.
So that just was going to be $20,000. It seemed like it came out pretty close, the number, but you're saying that didn't take into account profits?
Correct. That was the 50% of what the judge ultimately determined was the value of the business, not in consideration of all of the profits that had been received during those years of litigation prior to decree, but after date of service. In addition, the restricted stock units, we have several errors, legal errors in that area of the ruling. First, the court ordered the parties to calculate father's share of the unvested RSUs, 1,348. We believe it's the court's responsibility to do that. In addition, the court failed to take into account that those will not all be available for division because some of those have to be withdrawn or taken back by the company
if you can
pay
kind
for
of
taxes.
Explain the tax issue to us a little bit clearer.
Sure.
Because I think we do have a question about exactly how that works with the RSUs, why you believe they need to be held back or can't be split. Can you explain that to us a little more?
Sure. Mother's expert, Mr. Cantor, laid that out really well in his testimony, which I included quite a bit of that in my reply brief. But the way it works is that Mother's company, Microchip, they have to hold back a certain number of shares to pay the ordinary taxes. And so if you look at Mr. Cantor's report in the schedule where he individually lists each and every RSU grant, each and every ESPP grant, he lists the gross amount awarded to Mother, but the net amount that actually exists for division. And in this case, the trial court unfortunately went with Mr. Kotzen, father's expert's calculation, but Mr. Kotzen repeatedly in his testimony admitted that he only calculated the total amount awarded to Mother and he did not calculate the amount that was withheld. He just said the court needed to do that, and the
Explain
court
this
did
to
not.
me.
Yeah, sure.
They're awarded to mother, but the company retains them, and she doesn't have access to them?
Well, when they vest, the company retains a certain number of them, depending on how many shares it is, of course, to pay the taxes. Otherwise, the parties would have, a lot of taxes to pay. So mother receives the net amount, which is itemized in Mr. Cantor's exhibit to his report, where he lists, and I think we also copied some of that over into our reply brief as well, to show you the difference between the amount awarded and the amount that mother actually receives and what is available for division. So the amount that was awarded is not all available for division. That's the problem. So giving father 50% of that would give him a windfall, and mother would get less than 50% because the only RSUs to be divided are those that are, the net that are available.
So when they're divided, I'm just going with what the court actually decided. If father, and I'm going to use round numbers here, if father was given 500 shares and mother was given 500 shares, the company wouldn't hold back the 500, part of the 500 that has already been granted to father. They would take them all out of one. Can you explain that a little bit? Because to me, that's how it would happen. But the way you're arguing it seems that's not how it would happen.
It's my understanding, based on the testimony of Mr. Cantor, that when those shares vest, then, the company has to take out so much for payment of taxes, which is why in his report, he was able to show us how many shares she was awarded for every single grant, and then how many remained net after the company took those out. So it's my understanding they do that upon vesting. So the problem here is that the court used Mr. Kotzen's calculation of the total RSUs awarded to mother, which is not correct because those don't all still exist. Some have been withheld for taxes. And it would be the same for the future ones that have not yet vested as well.
Could you explain, you said the court was supposed to do this and the court left it to the parties. Do you mean the court left it to the parties to do later, or is the court just saying, I need the parties to tell me what they want? I'm not quite understanding.
Sure. That is with respect to the unvested shares only. The court ordered the parties to decide how those should be divided, which I presume would require additional expert work. The issue is that we
You're
don't...
saying that hasn't been done?
Correct.
So that would, okay.
That is correct, yes. The other issue with the RSUs is the fact that there are no orders with respect to taxes, with respect to division of, capital gains on either the ESPPs or the RSUs. And certainly just a simple order that says each party pays their capital gains on shares awarded to them, I think would be sufficient. But right now we have nothing to enforce at all. Let me move on.
So when we look at how
Sure.
the RSUs are going to be divided, dad gets half, mom gets half, let's just use 10 for a number.
Sure.
So each of them get 5. As far as what's held back for taxes by the company, couldn't you do through a quadro or something in that nature, saying whatever's held up in taxes, divide that equally between the parties too? Wouldn't that just be a natural consequence of an even division?
I don't believe it can be done with the quadro. My client did consult with the quadro attorney on that, but certainly an order that says...
Did consult or did not consult?
Did. A post decree did consult on that. It's my understanding that it can't be done. However, I think just an order that says, here's the amount of net shares that has to be divided, or that has to be determined, and then that should be equally divided, because those are the shares that are available for actual division.
What significance are you drawing from the fact that some of the RSUs were awarded before marriage, but seems like very shortly before marriage, how much of a difference does it make would it have made had the court said these should have been treated as, or if you use a formula, how much of a difference would it make when it's very, very shortly before the marriage?
Well, I think we have that issue, Your Honor, with respect to RSUs and again with respect to ESPPs. And, you know, that's, the court really should have made two findings. They should have calculated the separate interest from date of grant, date that my client received those awards, to date of marriage, and then the second calculation from date of marriage to date of service, which would terminate the community. It's certainly the lion's share is community, but my client still does have a separate property interest that should go to her.
Even assuming the point is an incentive to stay, and there's only a few days, they received a few days before the marriage, and if they're not going to vest and it's an incentive to stay for a few years, you're saying there's still a separate interest that needs to be computed?
There should still be a separate interest. Otherwise, I mean, if my client had not have been awarded those prior to marriage, there would be nothing to divide in the marriage. Nothing would have vested during marriage. So it seems pursuant to the fair and equitable nature of division of assets and debts that it would be only appropriate to award her, even if it's a smaller amount, her separate interest. I would like to just address the attorney fee award to father, which we believe pursuant to the trial court record is punitive and not just. The court's main reason for ordering mother to pay father $48,000 in fees was based on 4 claims that mother did not disclose things, most of which were actually disclosed or that she just didn't have. And one of those was actually father's own retirement. The court said mother did not timely present a present cash value of father's account, but father didn't present any at all. And mother did provide it, I think, when she realized father was not, and the court did consider that. And I believe that I've thoroughly briefed the others, but...
Was that the basis for the ruling? Is there anything, does it have the ruling also not turn on disparity of income, or is it, in your view, based entirely on a failure to disclose?
The order does say both, Your Honor. You are correct. Under ARS Section 25-324, the court did find disparity of income or financial resources as well. Our position on that, though, is the court didn't consider other factors. The court really only looked at wages. The court did not consider the fact that father had been receiving all of the profits and all of the benefits of the Amway business, many of which the court later found he's able to write off for tax benefits, so none of that was considered. Father used to be employed in the same type of industry as mother, and we believe he definitely could be earning more. He's at some point took a lower paying job.
You're saying that income from Amway, and is this income at what point? It wasn't community income that he was receiving? Or this?
What I'm saying, Your Honor, is after date of service.
After date of service, there was income, and that was
Yes,
went to him.
Correct, and that all went to father. And so there's issues like that, and father lived rent-free for 2 years, I believe it was, in the marital residence, while my client was paying a lot of those expenses, and also while my client was having to pay for an apartment somewhere else. So the home is a community asset. Father's the only one that got the benefit of living for free for 2 years. So we believe all of those factors should have weighed as well.
So you want us to consider your argument that mother was entitled to half the rental income during the period of exclusive possession by father, or do you want us to consider the fact that the court did not make that consideration, but it should be considered in relation to attorney's fees? We can't have it both ways. Which way would you like it?
I do understand that, Your Honor. We really were making alternative arguments, but in some capacity, it should have been considered one way or another.
Can you discuss the 401k issues? In briefing, you said there was separate property, but I cannot find in the record where that was established with evidence. Can you point me to?
I believe that was from Mr. Cantor. I understand mother had 2 401k plans and father has a pension. So mother had requested that those be offset against one another. Otherwise, mother will not get a portion of father's pension until he retires, which is probably a long ways off. And also just to keep the parties from being continually entangled in that. But my understanding is father has a pension, mother has 2 401k
And the court's not
accounts.
required to do that.
You are correct. That is correct.
And assuming he's not required, you have a problem with the way it was divided otherwise.
Well, my client's preference was to do the present value and the offsets to make sure that the parties didn't have to stay tangled and she could get her share of some things sooner as well as later.
Let me get to this. You make a claim in your briefing that there was separate property in the 401k accounts. Do you have any evidence to verify that, such as a statement pre-marriage or post-marriage? Is there anything in the record that would verify your claim that there were separate funds in those accounts?
I believe that it was in Mr. Cantor's report. I'm not 100% as I stand here today, but that, I believe, is where it would be addressed. Mother testified about that, and I know she testified about, how she calculated it pursuant to the formula. I can't say for sure where that would be. I
So
apologize for that.
counsel, I realize you just said that mother's preference was that the 401k, the retirement, be split a different way. What is the abuse of discretion by the court? Because that's what we're looking at, is whether the court abused its discretion. If mother just didn't agree with the way the court did it, that's a different issue. But what is the abuse of discretion that you're alleging?
Thank you. I think that relates back to the trial court's findings that no one provided the court with the valuation information, which mother had actually done through Mr. Cantor and through her retirement information she provided.
Thank you.
I'd like to reserve the remaining time if I may, if that's okay with the court.
Yes.
Thank you.
Thank you, counsel. When you're ready.
Thank you, Your Honors. May it please the court, my name is Edward Walneck. I represent the appellee, Santosh Kumbera, in today's case. I want to start where the court sort of ended with appellant, because I think it's valuable to state that with regards to the 401k, no evidence was presented at the trial level regarding any sole and separate interest. And this issue is really representative of a lot of the
Counsel
issues.
suggesting that something came in through Mr. Cantor.
And
Is that-
yeah, and I'll note that, Your Honors, that we talk about this on page 23 of our response. This whole idea that there could have possibly been a separate interest, they talk about it in their opening brief in Exhibit C. And our looking at Exhibit C was never admitted, it was in the pretrial statement, and it was never offered as evidence, and therefore never needed to be considered by the court. On our examination of the record, the closest thing we can see is some testimony by mother, but the court clearly found that the evidence and the testimony, I shouldn't even say evidence, it's just testimony, what the mother felt was insufficient to provide the court enough evidence to demonstrate that there was a sole and separate interest. And a broader point that this is
Was there a dispute? Did mother say, here's the amount that was put aside before marriage?
My understanding is that numbers were not provided, and that the only thing that gave an indication was, again, a unadmitted exhibit that was in the pretrial statement and not provided to the court. My understanding is no numbers of what was provided to the court in terms of sole and separate was at all. And I would just say that, and posit that the The trial court gave a pressure valve to this because in their order, they basically stated provide half of the retirement accounts was expressly for half of the community portion of the retirement account. So there is an aspect with the quadros when they're done that the quadro attorney, when looking at this, if they see something obvious, they can fix it, but nothing at the trial level was ever presented to the court to be able to make a clear finding of sole and separate property. And I mean, that kind of meets the old axiom of it's community until you prove otherwise. They had the burden to show it was sole and separate, and they just simply didn't.
I'd like your take on taxes at this point, because regarding the RSUs, it seems clear if the company is going to retain a portion of them to satisfy the tax liability upon their fully vesting, that you have to account for that, and it doesn't appear the court did. So explain to me if they did how.
Our argument, Your Honor, sorry to adjust the mic, but I want to make sure you guys can hear me well, is that the court was clear that the parties would share the transfer expense. And we would posit that that the court was taking into account not only, it says before the transfer expense, the cost of putting together the quadro, but uses the word transfer expenses. We would posit to the court that the transfer expense would encompass the tax liability as well, and that the court meant for that to cover that aspect of taxes, because already the first sentence before that, or at least the phrase before that, before the and, is the expenses related to the quadro. The transfer expenses are related to what would cost the company to then divide them out and basically distribute to the parties. And by what the appellants provided in information today, it seems like the company would withhold that amount to pay for the taxes.
And when you say it seems like the company would, is there anything in the court's order that directs the company to do that?
Your Honor, what the court did, and this is where kind of the issue comes up on this particular issue and some others, is that Mother and the appellant insufficiently provided enough information on this issue and many others related to the RSUs, the 401ks, the SPPs. So what the court directed to do is that it gave guidance of how to do this and directed a quadro or financial financial attorney to divide according to parameters that it put in place. At that point, I would assume that it would account for this right here and would take the directive of the transfer expenses, and the company and the documents would prepare. And remember, this is anytime a quadro is prepared, this is something that would be reviewed by the court and before the court signs it. One of the before I jump to another issue, I'm sorry, Your Honor.
What about taxes in regard to the ESPPs?
With regard to the ESPPs, I think it's similar. I think that the court used similar language with regards to the transfer.
It doesn't discuss, when you say similar language, you
Okay.
got vested and unvested RSUs, so we only divided the unvested ones. Everything else was divided as community before. So we've got
Okay.
this thing that is not right.
Okay. Are we talking about the ESPPs, RSUs, or?
Well, unlike the RSUs,
Okay.
the ESPPs are ready to go,
Mm-hmm.
ready to be divided. Nothing else needs to happen. So how do we deal with the taxes in regard to that portion of this? Whoever gets them pays the taxes?
Well, I believe that what the court, and I'm trying to get to my notes on that, Your Honor. Just give me 1 second. I apologize. There it is. Okay. The reason I want to refresh my memory on this is because there are those three distinct categories of the vested RSUs, the unvested RSUs, and then the ESPPs. So I guess, Your Honor, and with the questions, we're not really talking about what's community and not community, but rather how it would be taxed, correct?
Yes, there'll be
So-
tax consequences, and I believe opposing counsel's making the argument that we need to deal with the taxes in the decree, but do we?
And what we posited and we simply argued is that no order is required, and that each party would be responsible for their own taxes with related to the ESPP. In particular, that they cite to no law that where the trial court's required to consider a speculative tax obligation, and that each party basically can be subjected and decides when they're going to sell their ESPP shares. Because my understanding, when they're divided, each party gets theirs, and then they get to make a determination how they want to hold them, how they want to break them out, pay for them, whatever they want to do with regards to that particular issue. So
Each party bears their own responsibility for taxes.
that is our
Let's
position.
go on to the marital residence, because
Yes.
you've got a lot of issues.
Could I ask a question before that, back to the RSUs? Is there a question about whether the formula should have been used for some that were awarded prior to marriage? Mother is suggesting the court didn't treat anything as being separate property.
Well, I think there's two issues with that, Your Honor, and one is back to the maxim that I've stated that the problem with Mother's argument is that she, in a sense, wants a redo, but not a redo because of a legal error, because of a redo because she didn't present enough evidence to the
But
court.
she didn't present some evidence that some were awarded prior to marriage?
Correct. She did not extensively produce.
But no evidence that of the date they were awarded?
What happened is, Your Honor, with the RSU issues, they both provided experts on the RSU issue. Mr. Kotzen, who was the appellee's expert, father's expert, did provide opinions, provided the method that he thought should be used, whereas
Did his
Mr.
report indicate when they were first awarded?
I believe there were dates that were provided of when they were originally awarded, and his contention in his report's clear that they were awarded throughout the marriage.
There were some awarded prior to the couple's marriage, based on my review of the record. I'm believing it's 544 if we want to be exact. So talk about those.
Those right there, and I think the court left a pressure valve for that, because what the court wanted to do was that because of how it viewed the evidence that was being given to it as somewhat insufficient, that it left for the parties to meet with a quadro attorney or financial attorney to.
But I want to go back, because Mother's expert on the RSU issue, was that evidence included? Was that included in the record? Because my memory of seeing it is that her expert went and made perfectly clear as to what was separate, what had been obtained during the community. Fathers, though, did not do that.
Again, what my memory of the record and what my notes demonstrate is what Mother's expert did is he did calculations with each of the different vested methods and the amounts that were there, but that he didn't posit an opinion on what method to use. Whereas, and if I'm not answering your questions, Your Honor, just let me know, and I'm happy to take another stab at it.
I think the problem that I'm having with it is any property that is awarded or obtained prior to marriage is separate property.
Yeah.
And that needs to be treated separately. And so I'd like to hear a little bit more about why you think those 544 were treated appropriately and shouldn't have been treated separately.
And in our argument, and gleaning from the record and the court's orders, is that it specifically stated that it would divide the community share of the RSUs. It
But
specifically
if
states
they were
that.
issued before marriage, there is no community share.
Well, but there are portions of it that are, and I'm saying the portions of the RSUs that are community.
But doesn't the court need to identify which portions are community and which are?
Well, in this
separate?
particular case, the court did the best it could with the information that was provided to
But
it.
it doesn't seem to have done anything. It doesn't seem to have entered into any calculations reflecting that that this number, 500 and something, were awarded prior to marriage. Is
So-
there anything in the record that suggests that the court
Treated
treated those differently?
Okay. Going back to the record, because I have that flag down there, and we're talking about the RSUs, correct?
Correct.
And are we talking about the 544?
That were awarded prior, that won't vest until during the marriage.
Okay.
But were awarded, clearly were awarded prior to marriage. I understand it's pretty close to the date of marriage, but nevertheless, they were awarded prior, and there's got to be some element of separate property, I would think.
So, in my reading from the court is what they're saying is that based on what it was provided to, is those 544 particular shares were awarded to mother, and then they vested during the marriage. And because they vested during the marriage, hang on, I apologize, I'm getting, I think, the unvested and the vested a little bit crossed here.
Then the logic doesn't work very well with ones that are awarded during marriage but won't vest until after marriage. It seems like you need to use the formula to reflect some separate property interest in them.
But, and Your Honor, I guess what I'm saying, and where I would push back is, I think the court did that. I think the court, in dividing all the different amounts, and I'm just looking back at the decree, it did go through the various units and discuss what was vested during the marriage and became.
You're saying the court didn't just say the 543 are all community property because they vested during marriage?
Well, what I'm reading right here in particular is it gave out a number of finding that the 4,343 units is equitable, and that it found that they were vested during marriage and became community property upon full vesting.
But I think the issue is that the court on one end, on the front end, treated those RSUs differently than it did on the back end. Because if you look at, even if we take the court's reasoning to say that on the front end, it was an incentive to stay employed, and so that carried through into the community, the incentive to stay employed at the end of the marriage should carry through as well, and then those should be treated as potentially separate property and look at the vesting after the marriage, after the date of separation. The court treated them differently rather than treating all of them the same.
And I would just simply posit that we accept it, we have a discussion on our response, and I'd refer the court to that, but in addition to add to the information on there, is I think the court does describe in how it comes up with its number of 4,343 units, is it basically is putting together the 3,799 awarded during the marriage and the 544 prior to marriage. And I understand what the court's trying to say is I think what the court's maximum at the trial level was saying, what's vested during the marriage is what should be divided and what the court saw as community property.
Then if we follow your logic, wife should be awarded the 1,348 RSUs that had not vested.
Correct. Yes.
That didn't happen.
Is that those were acquired during the marriage were not vested prior to the date of service.
Correct. Let's move on, though. We've talked about this a lot.
And I just want to posit that the unvested ones is that I think at that point, then you have to use the Hug and Nelson method at that point. I understand, Your Honor, that it's kind of twisted in there. And what I'll simply say this is that I know by the court's logic and what it was using is that first with the vested ones, it used that when it vested, and the unvested one, it didn't purely, it gave a different method and a different way to handle that. I'll move on to a different issue because I know there's a ton of them in this particular case.
Let's get on to, your husband received exclusive use of the marital residence
Correct.
once the temporary orders were issued.
Correct.
Both parties contributed to maintaining the real property asset because it was community until divided by sale.
Correct.
Your husband,
Father got to stay in the house.
and didn't pay rent. Mother had to rent an apartment. that wasn't taken into account in the decree, was it?
So, Your Honor, what the court explicitly made a finding on is that that mother did not supply sufficient enough information, nor did she meet her burden to be able to make a finding that the court should award her anything for the time that father was in the marital residence.
Okay.
So I don't think there was enough evidence for there to
What
even make
evidence-
that step.
What evidence would have been necessary? What was missing?
Yeah, so in particular is that the court had stated that the mother didn't provide sufficient evidence of the money that she was spending, that she apparently needed reimbursement for, and that she didn't provide sufficient evidence to come up with a number that the court, that could have possibly been provided the court to basically calculate a number that father, or that she should have been given credit for. So that goes, again, to the maximum at the beginning of this, is that a lot of the issues brought up by the appellant in this particular case is that they're self-created. This is a self-created problem because she didn't produce evidence as in to figure out what that number would be.
So
Or
testimony is evidence, you would agree with me?
I would agree, Your Honor.
Okay, so she testified, I think it was $3,700. I'm trying to find it in this voluminous divorce decree.
Yes.
But I think she testified that the fair rental value of the property was $3,700, and you agree with me that it had some value.
I agree that it had some value, but based on the trier fact who we give basically the benefit of the doubt to.
We have evidence that it was $3,700. What is the contrary evidence in the record? Can you point me to that?
To the contrary evidence that she,
To the value of the rental. I mean, it has some value, you agree?
but I agree that it has some value, but I also think that the court was taking into consideration the amount of expenses that father was paying too. Your Honor, I apologize, I only have 45 seconds left, so I want to hit on two quick things. One issue that we haven't talked about is with regards to the parental issues. I would just simply posit to the court that there's absolutely no abuse of discretion by the court on this one. And the final one is to talking about our request for attorney's fees at this level and at the trial level. First at the trial
Just
level.
clarify, did husband provide contrary testimony to the $3,700?
I believe he gave testimony as to his expenses and to his.
But nothing on the rental value.
I think on the rental value, he provided his opinion on it and what the amount would be, is.
Well,
I assume
what
it
did he
wasn't
say?
zero. What did he?
I think he gave whatever the rental value was, and if it is $3,700, I'm fairly certain that's what he stated it on the record. But, Your Honors, I got to say this real quickly, I'm sorry. This is a unique case, and there's a lot of things that happened. This case has been pending for over 2 years. This is the first time I've ever seen a case where you had someone file an amended opening brief. I asked this court to simply consider an award of attorney's fees on behalf of father because how long this has taken, how many delays have been in place, and the unique procedural history that's taken place that has cost my client thousands upon thousands of dollars when it frankly shouldn't have. Thank you, Your Honors.
Thank you, counsel. When you're ready.
Thank you. I'm going to try to use my time very wisely. I'll just state quickly with respect to fees. We did attempt to file an amended brief. We had inadvertently left out some page numbers and found some errors and wanted to make those corrections. Unfortunately, I had COVID for months. I was hospitalized twice. On the heels of that, my husband was diagnosed with multiple tumors, was in MD Anderson Cancer Center for weeks. I got that filed as soon as I could. I would ask for the court's understanding and forgiveness in that regard. The bottom line is the court did not accept it, and so there was, and there wasn't anything super major. We were just trying to, make those corrections and insert those page numbers. Quickly, with respect to fees, mother has also requested her fees. I don't believe it's accurate that father gave testimony about the rental value. I believe that he testified before my client and he never testified again. I believe that's correct. In addition, mother did present evidence to the court of her sole and separate nature of the ESPP. shares. If the court would look at Mr. Cantor's report, and I believe my reply brief and maybe opening brief will address that for the court.
Was that actually admitted into evidence, or was it just part
Yes.
of a pretrial?
No, it was admitted into evidence. And then, in addition, counsel states that there's no need for an order about taxes, but we have two types of taxes. We have the ordinary taxes that are taken out when the RSUs vest, and we have capital gains taxes. And I cannot imagine not having an order that at least says each party pays his or her own share of capital gains based on the RSUs or ESPPs awarded to him or her. I think not having that is a recipe for disaster.
Wouldn't it be just divided equally?
Yeah, how so? If you are the
Sure.
owner and everything's been divided, you're divorced, you're responsible for your own capital gains tax.
Why do you need an order saying so?
I would agree with that. I just don't like to assume what the court meant, number one. Number two, my client being the employee, I just don't want her to be at risk of microchip taking that out or something. We're just trying to cover our bases and make sure that we don't have to go back on enforcement. Importantly, the court asked father about the fact that the court had ordered a division of RSUs that included ones that had already been withheld and no longer existed. And his response to that was that, well, the court ordered the parties to divide transfer expenses. Transfer expenses refers to the cost that will be incurred when those RSUs awarded to father are transferred to him. It doesn't mean that the parties are to divide a different amount. The court made very specific findings about how much had to be divided or how much was to be awarded to father, and those numbers are wrong. So ordering the parties to share the cost and the transfer of those RSUs does not correct the problem with awarding father essentially 50% of awarded shares when all you have left are the net shares after some of those awarded shares have been withdrawn. I believe my time is up.
I'll give you a final sentence.
Honestly, I just thank the court for allowing us to be here today and for your graciousness and your continuance. I appreciate that. I was extremely ill, and I appreciate the court's understanding. Thank you, and have a good day.
Thank you, counsel. Very interesting case. We've had to put on our thinking caps. We will continue to do so and issue a written ruling in due course. At this point, we are adjourned.